Welcome to the Plant Grow REAP podcast.
Okay, hello everybody and welcome to another episode of Plant Grow REAP. My name is Chenu. I'm a senior associate specializing in commercial law and superannuation at Aintree Group Legal, which is, of course, Aintree Group's accounting firm. I am here today with the lovely Liam, one of our up-and-coming young lawyers. Liam, would you like to say hi?
Yeah, hi. I'm Liam. I work in Aintree Group Legal with Christian. I specialise mainly in commercial disputes, litigation and dispute resolution. And it's great to be here.
It's great to have you. Before we start, because we're lawyers, I'm going to get some disclaimers out of the way. And the first thing is we've got two lawyers in the room, which means we are, on any one matter, going to have a minimum of 7 opinions. So we might end up disagreeing a little bit as we go through this, but we'll see how we go. Other than that, the other obvious disclaimer is that this is general advice only and it hasn't been prepared taking into account any one person's specific circumstances. That said, if you would like to go over anything that we cover today, we'd be more than happy to speak with you, so just reach out. And with that, let's jump into it. What are we talking about today, Len?
Today we're talking about the reforms to the unfair contract regime under the ACL. So late last year, on November 9, new laws came in about the unfair contract regime under the ACL that set out further prohibitions about terms that are being used in standard form contracts which are unfair. And previously, those did not really carry any significant penalties apart from those terms being void or unenforceable. Now, penalties now apply. And that's one of the major changes.
All right, so there are a few terms there jumping out already that I want to jump onto. First one, ACL.
ACL. So
Australian Consumer Law.
I always forget that
we're
always acronym.
Not talking about footballers doing their knees.
No.
So Australian Consumer Law, basically the replacement for the Trade Practices Act came into effect in 2010. So this stuff's been in effect for at least 14 years, but we're talking about specific changes, recent changes. Other couple of terms that you use there, standard form contracts, very interested in that. We'll get into that in a second. And we also started talking about unfair contract terms. So what makes a contract term unfair? What are we talking about there?
So when you're thinking about an unfair contract term, one of the main points is that is the contract term unfair if it causes a significant imbalance on the parties' rights in that contract? And is that term which is suspected of being unfair, is it reasonably necessary to protect the legitimate interests of those parties to the contracts? And would that term in and of itself cause detriment, whether it be financial or otherwise, to that party if it was applied and relied upon? So that's one of the main things. And there's the ACL helpfully actually lists potential clauses in contracts which could be, based on those facts, be unfair. And helpfully it's clauses that allow parties to avoid or limit performances of their contract, terminate the contract unilaterally, penalise the other party for breach of termination of the contract while not setting out any penalties for yourself, vary the terms of the contract, renew or not renew the contract, perhaps automatically and unilaterally, and vary the upfront price payable under a particular contract.
Okay, so these are just candidate terms. These are potential terms. They're not automatically unfair, but the ACL says this is something that is potentially likely to be unfair. So if we got a clause in there in the contract and it says that one party is allowed to penalise the other for breaching the contract, but it's not reciprocal, then we're potentially looking at something that's unfair, provided it touches off on those points you raised earlier about causing significant imbalance and causing detriment.
Yeah, that's exactly right. And one thing that we're looking at is, I guess, the one-sidedness of those terms.
Okay, exactly. Now, there are a couple of exceptions. Actually, frankly, this is the law, so there are going to be myriad exceptions, but there are a couple of exceptions I want to get out of the way up front. And these are terms that no matter how outrageous they appear to be on their face, they're not going to be considered unfair. Now, what are those terms?
So those terms could be anything, just because something is in a contract and it might, seem one-sided, it doesn't automatically make it. So could be clauses that define the main subject matter of the contract, clauses that define goods that you're buying in the case of an insurance contract, that defines what's being insured, contracts or even clauses that set up the upfront price payable. It won't. The regime doesn't necessarily attack the price that is defined up front, but clauses that set out contingent prices, payments that are conditional on some other event occurring, those can be unfair. So those are some examples.
Okay, so let's say we engage an architect to provide some architectural services, and the architect gives us their standard contract. And that standard contract has a clause that says, these are the services I'm going to provide, and these are the services that I'm not going to provide. That clause will not be subject to these terms because it's defining the key subject matter of the contract.
Yeah.
And if the architect says, my upfront fee is $10,000, nothing more, that clause is also going to be fine. Even if it actually says my upfront fee is going to be $200,000 and it's ridiculously not market value. But if there are clauses in there that says, well, I can unlock other fees as we go through and as we hit, potential contingencies, those terms are subject to this regime. Is that correct?
That's correct.
Yep. Okay. So who's actually protected under this regime? We've got these legislative rules that are saying contracting parties, service providers, people who sell goods and services have to abide by these terms. These provisions, who are they protecting? What type of customer are we looking at here?
So to be, very colloquial about it, is really about protecting the little guy in this case. It's not really worried about big businesses. So the two main focuses that it's designed to protect is the individual consumer and the small business. And for that to apply, and when you've got a consumer as an individual, of course, that's an individual who's receiving, goods, supply of goods or services, financial products, services, sale or grant of an interest in land, and the individual who's receiving those goods or services is wholly and predominantly for personal and domestic or household use, and that's quite literally using the language of the legislation. And also small businesses. One of the really interesting parts of this regime is that it's actually expanded the definition of a small business under this regime. So small business now is defined as one that employs fewer than 100 people or has a turnover of less than 10 million for the previous year. That can be complicated by subsidiaries. You might think you're dealing with a group, but in fact you're dealing with a subsidiary within that group that actually meets the definition of a small business. So the idea of a small business that definition has actually been expanded to protect more small businesses. So those are the two main types of people who can be party to a contract that this regime is designed to protect.
Right. So we need to see that that the customer is a consumer, that's buying something for their own personal use, or otherwise it's a small business that's using something or buying something that they use in the course of their business.
Yeah, correct.
Okay. Standard form contracts. This is essential to this regime. The regime will not apply to a commercial contract that's negotiated over an extended period of time between two commercial parties who are on more or less equal footing. It applies to a standard form contract. And the easiest way of explaining a standard form contract in a single sentence is to say it's the contract that's given to you on a take it or leave it basis.
Yeah, that's exactly right. Yeah.
But I think we can go deeper than that.
We can, and I like to really focus on the examples. So when you hear those words, standard form contract, it's non-negotiable. It's very pre-written. It's the same standard one that they give to all of their customers or clients. Think about telephone contracts. You're getting a new plan on your mobile phone or a gym membership. Terms and conditions when you order something through, JB Hi-Fi, or you get
I
those.
think anything, when you're online and they say click this box, anything like that, it's going to be a standard form contract.
Yeah, no, you can't be, ordering something on JB and then, being like, oh, not too happy about these terms. Do you really think we could
Call up
negotiate?
JB's legal team and haggle over clause 8.
I'll have my guys contact your guys. You can't do that. It's a case of you either accept it or you don't. And that's take it or leave it.
Okay, now, again, there are always some caveats or exceptions to this position. So if we were to have what is essentially a standard form contract, but we do actually engage in some negotiation with the customer over payment terms or one specific clause, but the rest of the document is still the same. We're still going to have a standard form contract in front of us, aren't we?
Yeah, we are, absolutely.
Yeah, you can't get out of the definition by simply engaging in some sort of, short-term negotiations over one term. Right. I mentioned earlier that the ACL, the Australian Consumer Law, has been in effect since 2010. We've had prohibitions on unfair contracts in this country for a very long time. 2024, why are we talking about this all of a sudden?
Because these changes were quite significant. Because prior to this, if the ACCC gets involved or you're taken to court over a particular term in the contract, usually what would be decided is that, hey, that term, we believe it's unfair, it's now void or unenforceable. And that was really the extent of the punishment. So this is now something that they've looked at and said it's actually an offence to have an unfair term. Any standard form contract has an unfair term. That's now essentially illegal. It is legal. It's an offence.
Yeah,
you cannot do that.
And it goes beyond that too. So it's not just going to be an offence to actually have and use a standard form contract with unfair terms. It's going to be an offence, a separate offence, to also try and enforce those unfair contract terms. So let's just say you had your non-compliant contract out there, but you'd never been caught. And then you decide that a customer's in breach of one of the unfair terms. If you were to try and enforce that, that is going to be a whole new separate offence.
Yeah, exactly. And it goes back to the old saying, what people used to joke around, it's not the actual crime itself, which is illegal. It's when you get caught doing it. And that's essentially what's at play here now. If you're trying to rely on it, you're trying to enforce it, considerable penalties will now follow.
Okay, and let's talk about those penalties because this is remarkable. This is genuinely striking. So we were joking earlier about asking people to call in and seeing what they would guess the penalties are going to be. I think a few of us are going to be a bit flawed when we see what the numbers are. Liam, I'm a sole trader. I'm an individual running a business and I've got a non-compliant contract and I've committed a contravention. What's my maximum penalty?
Your maximum penalty per contravention, might I add.
This has got deal or no deal vibes going on right now.
Per contravention.
Per contravention.
2.5 million.
Now that's basically instant.
That's instant insolvency. Yeah.
Says the insolvency practitioner.
Now I'm knocking on the door. Yeah.
Yeah, exactly. Liam's getting a gig out of this if you're running around with a unfair contract term in your contract. All right, that's the individual. Let's just say we're instead talking about a corporation. And I think when we start looking at these figures, it becomes clear that the legislation is certainly targeting the big companies, telcos and banks and utility companies and what have you. Let's start talking about what their contravention penalties are.
So for their contravention penalties...
You've got like a drop-down menu for this one.
Oh, yeah, they just take your pick. It's a bit of a smorgasbord. But the floor, the absolute floor, again, per contravention, it's 50 million.
50 million per contravention,
50 million
minimum.
Or, it gets better, 3 times the value of the benefit obtained from trying to use that unfair term. That's if that can be determined.
So, let's say that the revenue that you generate through your unfair contract term, it generates $200 million. Well, a third of that will be greater than 50 million, so they'll apply that 1/3 of the benefit.
Yeah, nice, quick math. Good.
Assuming you can calculate it. Yeah, you notice I didn't actually calculate what a third of 200 million was? I just left it as some abstract figure. Okay, if we can't determine the value of the benefit obtained, then what's the third option for the penalty?
30% of that corporation's adjusted turnover during the breach period, which is a period of at least 12 months. So essentially, that period where that breach occurred, whatever your adjusted turnover was, 30%. Thanks very much.
Okay, excellent. We've got a complicated formula that's working out some pretty big numbers. What does this apply to? We're looking at contracts that are brand new, that are entered into after 9th of November 2023.
Yep. And also existing contracts that have been varied after 9th of November 2023 as well.
Okay. Those are obviously significant sums, so I think it behooves anyone who is using standard form contracts to consider this issue and review the documentation, because the penalties would essentially be business ending.
Yeah, and I think we were joking about this before, whether the ACCC or the government were trying to have a carrot or stick approach with these penalties, and we joked that it's not a carrot or stick; it's a carrot and a club. Essentially, it's significant.
Okay, I think we've set out like the general topic, and we've worked out the parameters of the playing field. But I like to get into case studies and get into war stories, because firstly they're entertaining, but also secondly I think they help us illustrate some of the points that we're trying to get across. Now, these rules, they're new changes. They came into effect very late last year, which means that most of the case studies, in fact all of the case studies I should say, were applied under the old rules, which means that the regulator couldn't pursue penalties and was generally pursuing enforceable undertakings not to do it again, which kind of gives you an indication of how toothless the old regime was. These case studies will end up having significantly different outcomes under the new penalties provisions, but they're also useful illustrations for us of the principles that we're trying to get across. So our first case study, we're looking at unilateral price increases and the ACCC and Servcorp. And obviously when we say ACCC, we mean Australian Competition and Consumer Commission. So that they're one of the regulators of this regime. Tell us about this.
So this is a personal favourite of mine when it comes to unfair terms. So Servcorp is essentially a business that provides serviced office space, secretarial and IT services. Necessarily just leasing out the service offices to its customers, and they've got their main company and then their subsidiaries that within each city or state provides those services. So the ACCC in 2016 and 17 starts getting complaints from people who were customers of Servcorp. They say, "Hey, I've been locked into another contract even though the other term expired. I didn't want to renew the contract. Now it's been renewed. I had no idea. And now the price has gone up significantly." The ACCC starts investigating, then commenced proceedings in 2017. And so what had happened and what Servcorp subsidiaries were doing is that if you were a customer and you're coming up to the end of your contract term with Servcorp, and there's a particular notice period, and if you don't opt out, it's automatically renewed and you're locked in for another term. But not only that, now the prices are higher.
We're jacking up the price.
And also, if you want to get out of it, you're going to have to cop a termination penalty fee, basically is what they're saying. And if you want to get out of it, well, you're just going to have to wait till the end of the term comes around again and you opt out. during when that notice period is. If not, too bad. And the ACCC, Servcorp, they're in
Wait,
court.
I'll just stop you there for a second. Tell us about the security deposit clause.
Oh, I always
I
forget
love
this
this
is
one.
my
This
favourite
is
one.
remarkable.
Yeah, I think we were joking about it before. We were like, this is no longer an unfair term. We're now in unjust enrichment territory.
Which
So-
qualifies as legal humour.
to me anyway. So there was a term. The court, by consent of the court declared that there were 12 terms in standard form contracts that Servcorp were using that were unfair. And one of the bits was that if you, the customer, didn't request back your security deposit at the end of the term, too bad, you've lost it. That's now Servcorp's.
If you don't ask for your money back, we're keeping it.
we're keeping it, finders keepers, basically.
That might be unfair.
So, and so because they're limited by essentially the legislation of its time in 2017, there were unfair and contract terms, and they were void and unenforceable. And those included automatically renewing the contract unless the customer had opted out, permitting Servcorp to unilaterally terminate the contracts without having to cop a fee, which is completely the opposite for its customers, unreasonably limiting Servcorp's liabilities or imposing unreasonable liability on the customer. And then, one of our favourites is keeping the security deposit. And the court ordered that Servcorp would have to implement a compliance program and review their contracts to make sure they're all compliant with parts 2 to 3 of the ACL.
If we go back to the definition of unfair, we can see that there's imbalance, and we can see that this is definitely going to cause detriment, but we can't see that this is reasonably necessary to protect Servcorp's legitimate interests.
Yeah, exactly.
Right. So that's how the unilateral price increase clause is deemed to be unfair.
That's exactly right. And I will add that the deputy chair of ACCC at the time, that he noted that, look, nothing we can really do. Penalties don't apply. We can only have them void and unenforceable. But he said we'll keep trying to bring up these unfair terms and challenge them in court where possible. So you can really see that the ACCC in this case would have felt that penalties would have been necessary.
Okay, excellent. All right, next case study, ACCC versus Cardtronics. I should say ACCC and Cardtronics. One of the things that's going to become evident with these case studies is that each case study is often a good example of multiple unfair contract terms. But the one that we're going to focus on specifically with Cardtronics is automatic renewal clauses as opposed to unilateral price increases. Cardtronics is they're those guys that put those nondescript ATMs that you sometimes see in shopping centres or shops. Or, they're not branded as Bank of Melbourne or Westpac or anything like that. They're just a generic ATM that's going to charge you a high rate of service fees.
Usually an indicator that you're in the wrong part of town.
Yeah, not a good sign. They would enter into contracts with shop owners, businesses trading from premises to set up their ATMs in those scenarios. In those shops. And these contracts would include a number of clauses that were potentially unfair, allowing them to unilaterally increase fees or unilaterally decrease amounts payable to the shop owners if they had incurred additional increased expenses that they wanted to offset. Cardtronics also had a first right of refusal. So even if the contract was coming to an end and the shop owner wanted to use some other ATM provider, Cardtronics had a right to match the financial terms offered by any other ATM issuing company, which I think is a first right of refusal is aggressive for a standard form contract, I think. And they also had a clause allowing them to automatically renew contracts. So essentially, if the shop owner did not provide written notice 6 months out that they wanted to terminate, then Cardtronics could just automatically renew the contract. So again, a bit similar to Servcorp. ACCC said that's not fair. Cardtronics essentially agreed and gave enforceable undertakings. The ACL identifies this type of clause as a problem area. So clauses that allow you to unilaterally renew the contract term is going to be a potential issue. If the terms only allow the business and not the customer the right to renew it, that's where you sort of end up in that territory. And again, we need to show that it's not reasonably necessary and that it's causing detriment. So we might have contracts for utilities, internet, etc., that roll over essentially. If the customer forgets to renew, then they're still allowed to continue providing those services and roll it over, because in that case, it's in the interest of the customer. But when we have something like this, then we're really looking at entering into that unfair contracts area. Okay, next case study. We're going to go into, I promise you this is not for a cheap laugh. This has legal merit to it.
Christian's been waiting a long time to play this.
I'm very excited. This is from the well-known legal case study of Darth Vader and Lando Calrissian. Just let me play a little clip for you.
Calrissian, take the princess and the Wookiee to my ship.
You said they'd be left in the city under my supervision.
I am altering the deal. Pray I don't alter it any further.
All right, Darth Vader, in case you don't know, one of the movie's all-time greatest villains in this particular case is essentially struck a deal with a character that says, you do what I say you do. And I'm going to say that any time Darth Vader strikes a bargain, it counts as a standard form contract, because I don't believe anyone actually negotiates with him. He doesn't do that. But Darth Vader's position essentially is that I am entitled to unilaterally amend the terms of our deal whenever I feel like it, in whatever way I see fit. Liam, give us a legal analysis of Darth Vader's position.
First off, Darth Vader's clearly taking advantage of a small business owner, Lando Calrissian. I won't go into it any too more than that. I don't want to expose myself here as being a Star Wars nerd, but this is a classic case of unilateral termination and an amendment. And the ACCC, if let's pretend that Darth Vader is a trader in Australia, they would say that's completely unfair. You can't allow a supplier to vary the product or service or the price without giving the customer notice or the opportunity to terminate that contract. Even allowing the customer to terminate the contract, the customer has incurred significant upfront costs, which will be lost if the contract is terminated early. Travel logistics, building contracts might be an example of this. And look, ACCC has also said that advance notice of the amendment may not be enough to make the contract term fair, and that's depending on the whole rest of the contract. And instead, the ACCC's advice on this is unilateral variation clauses may be considered more acceptable if the variation power is more clearly expressed. And that only goes so far as necessary to allow the business to achieve its legitimate business interests and provide that balancing right, such as ability for the customer to exit the contract without penalty where the change should be materially detrimental to them. And guidance from the courts on this in terms of these unilateral variation termination clauses, it suggests that that clause should require the party varying that contract to be act reasonably to the extent reasonably necessary to protect its business interests, give advance notice, and not financially penalise the customer for choosing to terminate that point. Poor Lando Calrissian in this opportunity, he could not do anything about that. Otherwise, he would probably be suffering from the same fate as our poor other sole trader.
And don't worry, I'm sure the ACCC will protect Lando from Darth Vader.
I hope that they would.
Okay, next case study, unfair indemnity clauses, ACCC and Warrnambool cheese and butter. What are we talking about here?
So we're talking about this is a more typical way of how the ACCC operates with unfair terms and undertakings rather than going to court, because this matter did not end up proceeding to court, fortunately. Warrnambool Cheese and Butter Factory Company Holdings is the full business name, and I'm just going to call them WCB for the sake of time. They had a milk supply agreement with farmers, and the ACCC contended that those contracts that they had with farmers were unfair. These unfair terms included the ability for WCB to unilaterally vary their milk prices. Farmers were unable to terminate the agreement without incurring a financial penalty. Restriction on farmers selling their own land and unreasonably required farmers to even indemnify them for any loss which could have been avoided or mitigated by WCB themselves. And the ACCC finds out about these contracts, has a review, and says, look, we find that these terms are potentially unfair and you need to fix them. And initially WCB says, look, we disagree with this. We don't believe that at all, that these are unfair. And more than that, no one's ever complained about them. None of these farmers have complained about these contracts, or they've never said that these terms are unfair. And they say, look, well, the ACCC says, I'm the ACCC, I think they're potentially unfair. WCB says, look, fine, no worries, we're going to take steps to address this. And they redo their contracts, and they now no longer impose penalties on those farmers who are terminating the agreement before the expiration date. They're now not going to withhold consent from a farmer wishing to sell their farm, and now they've narrowed the scope of the indemnity that they're required from the farmers. They submit this to the ACCC, and the ACCC is satisfied, and they said, look, I think that's fine now. You're free to go. Well done. You're not going to get sued. And I think this case really kind of highlights that significance of that imbalance. And when you're looking at an imbalance, it is usually very indicative that can drive the impression of a term being unfair. And one of the key examples I really took from this is that the restrictions from someone being able to sell their land. Couldn't do that under this agreement. And also, the indemnity as well, unilateral and unreasonable indemnification, which they've had to narrow. And that is really indicative of an imbalance there.
Yeah, you can't expect your customer to indemnify you for your own costs that you incur while you're busy enforcing unfair terms.
And this is a classic thing when we talk about commercial disputes as well, is that we always talk about, well, what did you do to mitigate or avoid that loss? And in this case, what did WCB would just say, well, I'm not beholden to that. And that goes against a very critical legal principle.
Okay, next case study. Restricting commentary about businesses and non-disparagement clauses. So this ties to ACCC and Fowler Homes. Now, Fowler Homes is the manufacturer, or is a residential home builder, and they use standard form home building contracts. And those contracts include a number of clauses that were potentially problematic, including prohibitions saying that the customer is not allowed to publish or disclose feedback online about the experience that they've had where that feedback is negative. They require their customers to obtain permission from Fowler Homes before they can actually post public comments and reviews. And then finally, again, one of these indemnity clauses that they say the customer has to indemnify Fowler Homes for the costs that Fowler Homes incurs if they try and, if they generate legal expenses while trying to enforce this non-disparagement clause. And the ACCC said that these terms are likely to be unfair, and Fowler Homes again gave undertakings not to do it and sent out corrective letters to their clients. Now, non-disparagement clauses, these are common. Right? We see these in commercial contracts, but they're usually in commercial contracts where we've had two parties negotiating a commercial transaction over a period of time. When you stick them into a standard form contract, they start to take on a different nature. They're a bit of a different beast. And in essence, they run the risk of being unfair in that they can restrict your customers' freedom of speech and do so in a way that's really not necessary or not reasonable for you as a business to protect your legitimate business interests. So the ACCC is on record as saying a standard form contract that prevents or limits the customer from making public comments about goods. This is likely to be unfair under the ACL. These clauses, though, there's judicial guidance and commentary from the ACCC that suggests that there are ways that you can mitigate this and potentially rehabilitate the clause. So the first thing is you make sure that it's not unilateral. You make sure the clause goes both ways. So theoretically both parties get the benefit of the non-disparagement provisions. But you also include in there wording that says that the non-disparagement restriction is just there to stop beliefs that are not reasonably or honestly held, which is another way of saying slanderous posts, defamatory comments, things that are outrageous but obviously not true. If a customer wants to go online and say, look, these are the negative experiences that we had, and they got a legitimate reason for believing that there were negative experiences, that's fine. If they want to go online and, slag off the business and make outrageous accusations, you aim at trying to restrict and prevent that type of comment. So non-disparagement clause doesn't have to be unfair, but depending on how you word it and the context of the contract as a whole, it can be unfair, but it can also be rehabilitated. So I think that's a good example of how these unfair contract terms, they're not black and white. It's not a black and white assessment that, yes, this type of clause will always be unfair. You need to consider the interests of the business that's trying to enforce the clause and consider the nature of the contract as a whole. And you probably also need to consider whether the clause is transparent. And that's another key factor. And again, it leads us into our next case study. And Liam smiles at me as I start rummaging through the computer to bring up our next audio clip.
What kind of accidents? I didn't know we had to sign anything for this tour.
I can't see what it says in the bottom.
Violet, you first. Sign here.
Hold it. Let me through here, you kids. Violet, baby, don't you sign anything there. What's this all about?
Standard form of contract.
Wait a minute. What's all that small print there at the bottom?
Oh, if you have any problems, dial information. Thank you for calling. Mike, Augustus?
Violet. Violet.
I assume there's an accident indemnity clause.
Never between friends.
Okay. I love that clip. I love the indemnity clause, never between friends bit. Where on earth has that come from?
I'm start using that, I think.
Yeah, that's come from Willy Wonka and the Chocolate Factory, and Willy Wonka himself describes what he's doing right there as a standard form of contract. So it's tailor-made for our present purposes. For those who are not familiar with the scene, Willy Wonka, before he takes the kids on a tour of his factory, at the last second, without any heads up, he displays a indemnity waiver in front of the kids and requires them to sign it before he'll let them in. And this indemnity waiver, it's this gargantuan document. It is famously nonsensical. It is just full of legalese, which means absolutely nothing. It goes around in circles. It's got large chunks, large provisions in there are in Latin, and you look up the translation of the Latin, and the Latin itself is gibberish. And then it's got clauses at the end that are infinitesimally small. You cannot read them. They are that small. The net effect is that not one child, putting aside the legal implications of trying to get a minor to sign a legal document, not one of the signatories to that indemnity has the slightest understanding of what they're actually reading. And even if they tried to read it, they couldn't possibly understand what they're agreeing to do. The key point is that this all goes to the questions of transparency. So when we consider whether a term is unfair or not, it's not just a question of considering the actual legal content or merits of the term. We've also got to have a look at whether the term itself is actually transparent. So a lack of transparency in a standard form contract may in itself be the cause of the significant imbalance between the two parties. And a term will be considered to be transparent if it is expressed in reasonably plain language, it is legible, it is presented clearly, and it's readily available to the parties to the contract. So if you want to attach your T's and C's to a contract by hyperlinking them, if the hyperlink doesn't work, that's going to be a problem, and it's going to go towards transparency. Terms that may not be considered transparent, stuff that's hidden in fine print. stuff that you bury in a schedule knowing that no one will ever actually get around to looking at it. You phrase it in legalese, so even professionals have difficulty understanding what it means. Or if the term is just ambiguous or contradictory, all of this goes towards transparency, and by extension, all of that goes towards fairness. Now, a term that's not transparent will not necessarily be unfair, and a term that is transparent will not necessarily be fair. But it is something that we need to consider. So key takeaways on that point, you're probably looking at a term will be transparent if it's in reasonably plain language. Can your customers read your contracts and understand them? Using clear and simple language in your contracts. Transparency, just ensure that your key terms are clearly drawn to the attention of your customers during the sign-on process. And indeed, if you have to renew contracts, then you probably need to draw the key terms to the attention of the customer again during that renewal process. All right, where does that leave us?
Well, one more thing I was going to add to that is please don't put any Latin in your documents because, unfortunately, prior to 9th of November 2023, I was almost writing all of my contracts exclusively in Latin. Fortunately, I can't do that anymore. So not sure where all my Latin skills have gone now.
I have nothing to say to that. If you had to put a contract in front of me written in Latin, we would have been having a meeting. Okay. Aintree Group Legal. How could we help Willy Wonka?
Well,
Do you see how smooth that transition was?
Yeah, that was good.
Yeah,
He's famously a client of ours. We usually just do use professional negligence and
Wrongful death
and personal injury. But in this case, if he would have come to us, in this case, we would have reviewed these contracts and we would have said, okay, first off, buddy, cut the Latin and cut out the legalese, and we would have made sure that these terms were fair. And that's something that Aintree Group can help with. If you can come to us and you can show us your contract, we can review it for you and go with it with you, and we can make recommendations and how you can improve that contract to make sure that it is compliant with the new regime. And just the other day, we received a contract for a client we were reviewing, and it was for something completely separate. And it was one of the first things that jumped out at me. I noticed a few firms were maybe potentially unfair, and pointed those out to them, and they were really grateful. So it's always important to think that you're not everyone is always safe. You might think that I don't have anything that's unfair. You never know, and it's always important to can come to us and we can talk to you about it.
And these rules are in effect. This is not hypothetical. This is not something around the corner. This is now.
This is
2024. All right. I think we've gotten to a pretty good place. I'm feeling good about it. Anything you want to add?
No, I feel great too. That I no longer have to use Latin. It's fantastic.
Excellent. I can't believe we need to change the ACL to actually get you to stop using Latin, but there you go.
They made these changes because of me. I think that's the reason.
If for no other reason, it was worthwhile if the Latin maxims disappear. Okay. Other than that, we'd like to thank you all very much for listening to our episode. If you enjoyed our show, please rate and review us on Apple Podcasts or on Spotify, as it does help other listeners find our show. And be sure to tune in next week for our next episode. I'm Chenu, and this was Liam McColl. Thank you very much.
Thank you.